What you know, alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Monday, October 27th. Not going to be a super long episode, but we do have some updates in some of the cases that we're covering. I was thinking today, it's been well over 5 years. I mean, we're coming up on 6 years since the kids were reported missing. And we're starting to get to the restitution hearings, which is the end of the road. Other than appeals coming up, it will be largely quiet from here on about Lori, unless something happens in prison that is newsworthy that gets out. We're also going to cover Kouri Richins. Her attorneys are responding to some filings by the state that we went over last week. And finally, just a small update in the Celeste Rivas Hernandez case. Not a lot of news coming out officially, but private investigator on the case finding out a lot more than what we've been told by the LAPD, and then we'll wrap it up. So, Lori's restitution hearing took place Friday, October 24th. Prosecutor Trina Kay says that they did the mileage but forgot to remove the gas receipts and told the judge to remove $348.98, which would make the total restitution owed $8,654. They asked Lori if she stipulated to anything regarding restitution. Lori said that on Wednesday night, which would have been the 22nd, she got the documents from her advisory counsel. Then she learned there was another document sent to her attorneys on Tuesday, the 23rd, and that document she has not seen yet. She says she understands that counseling costs can be included in restitution, and by counseling costs, she means the counseling that Kay Woodcock has been receiving since all of this unfolded, and understandably so. But the documents turned over by the state totaled $3,147 for that counseling. But to her knowledge, there's been no invoices from doctors or insurance companies. So the document in and of itself seems to be insufficient. But she said based on how her trials were conducted, regardless of what she says or does, the judge will order the restitution, and so she's willing to stipulate. She also says that she understands she's been ordered by the court to pay over $534,000 for fees, fines, surcharges, and court fees, and says so you can add Ms. Woodcock's total of $12,096.97 of restitution to my tab. Trina Kay says that with the correction she talked about previously, the total restitution would be $11,747.99. That would be for Kay Woodcock. The judge verifies with Lori that she stipulates to that amount, and she says she does. He asks the obvious questions. Have you been under the influence of any drugs, alcohol, or medication within the last 24 hours that would have affected her ability to make that decision? Lori says, have I been on any drugs, Your Honor? Is that what you're asking? He says, no, I'm asking, have you had any drugs, alcohol, or medications that would affect her ability to understand or make the decision today, meaning she stipulates. Lori says, is Your Honor aware I'm in prison? I have no access to those things. So the answer is no, I have not. He asked if anyone has promised her anything, forced her, threatened her, or coerced her to agree to pay restitution. And Lori says, only my trials, Your Honor, coerced me. So the judge ordered that restitution and says that Kay's portion of the restitution takes priority. That would come out from the maximum allowable rate out of her prison accounts, meaning when money is put on her books, a certain percentage will be deducted from what she actually can spend, and that money will be forwarded to Kay. Trina Kay reminds the judge they are still awaiting restitution amounts from Brandon Boudreaux. Once that is put together, she will submit that to Lori's advisory council, as well as Lori's investigator. She mentions it seems Lori's investigator is able to get this information to her a little quicker. She says Ms. Woodcock is still ongoing counseling, so there could be subsequent requests for more restitution. The judge says that the court retains jurisdiction over restitution as long as Lori is serving her prison sentence. So for now, he will not set a future date for a restitution hearing. However, he will wait for one to come in. And that was it. It was really quick, under 10 minutes. East Idaho News was the one that streamed that. And you can go over to their channel to watch the live hearing. Moving on to Celeste Rivas Hernandez. We know her body was found in singer David's Tesla, and there's been very little come out officially from the LAPD or the coroner's office where, as we know, they are awaiting toxicology results. However, Steve Fisher is a private investigator who was hired by the homeowner of the house that David was renting. Mr. Fisher was on court TV and gave a little update of what he's found so far, which is very interesting. He got a video of the last person to drive that Tesla. The video is from down the street, and it shows the car being moved on July 29th around midday. And get this, it is the same day David left to go on tour. That first stop for him was in San Francisco. Mr. Fisher noted the car was dirty, just like it was found in what we've seen in photos. Clearly, this car had not been driven in a while. The other thing he said, which is big, he knows who drove that car to the final parking spot, but he did not disclose the identity of that person, obviously not to interfere with the official investigation by the LAPD. On X, Mr. Fisher posted that the day Celeste was reported missing was the same day that home was rented by David's manager. The other thing I'm curious about is why have we not seen him arrested at minimum for what allegedly was an inappropriate relationship? I'm sure they are building their case, gathering their evidence, and if he is charged with that, we talked about this on a prior episode, you were talking about some huge charges that could put him away for pretty much the rest of his life if he were to be charged and convicted of an inappropriate relationship with a 13-year-old. We will have to wait and see. Sometimes these things are a marathon and not a sprint. It can get frustrating waiting on these charges to be brought forth, but at the same time, we always want to make sure these cases are ironclad so that when somebody is charged and it goes before a jury, it's a solid case, and if a conviction is handed down, then there's not much there on appeal, and that the person responsible just goes away. So we will keep an eye out for any updates. Moving on to Kouri Richins. Just a reminder, we did an episode on this last week where the drug dealer, Robert Crozier, changed his story, saying he did not sell the housekeeper, Carmen Lauber, fentanyl, but did admit to selling her OxyContin. That's key because toxicology showed Eric Richins died due to a fentanyl overdose. Robert claims he originally said he sold fentanyl when he was detoxing and essentially made a mistake. Didn't mean to say fentanyl. Her attorneys are asking the judge to determine the credibility of Robert. In a filing on Thursday, the defense said the state has relied on only one of the corroborating witnesses, Mr. Crozier, to testify that the pills provided to Ms. Lauber were in fact fentanyl. He is the only witness who could potentially claim a direct connection between fentanyl and Ms. Richins. However, now that he has stated under oath he did not provide fentanyl to Ms. Lauber, the state is asking the court to find one of their most important witnesses is no longer credible. They go on to say, although Mr. Crozier's credibility will be determined by a jury, but at this stage, they want the court to listen to Mr. Crozier to make that determination. Notably, it is never the job of the prosecution to determine the credibility of a witness. They want a hearing to observe Robert's testimony and demeanor, and also to decide whether his credibility is sufficient to support Kouri's claim that there is no longer substantial evidence to support a jury verdict of guilt. They also say, should this court find his testimony to be credible, the weight of the evidence in this case will be significantly changed from that which existed at the time of the last detention hearing in this manner. Just a reminder, they're asking for another hearing about bond. Although I don't think she'll get bond because she's still charged with murder. They say the elimination of the state's alleged link of fentanyl to the defendant is a material change in circumstances, and without it, the state can no longer claim the existence of substantial evidence sufficient to support a denial of bail. The defense also replied to the state's filing where the state said they had no exculpatory evidence to give to the defense. The defense says that this was not the state's determination to make. Clearly, Robert's statement recanting that he sold fentanyl is more potentially exculpatory, yet it was not provided to the defense. Therefore, the state should be required to turn over all statements made by witnesses as stated above, so the defense has all potentially exculpatory evidence prior to trial. That is going to come down to who the jury believes. Do you believe the housekeeper who knew Eric and actually felt horrible once she realized what this fentanyl was for? Or are you going to believe someone who was in jail, detoxing from drugs, who was a drug dealer? Of course, we can't predict what a jury would do, but to me, I know who I would believe. I think this is a non-issue, but that's just my 2 cents, which is worth nothing. Moving on, the Summit County Attorney's Office has also responded to Kouri's attorney's request to have Eric's sister Katie, who is over the Eric Richins Trust, hand over financials, saying that she may have paid people who will be prosecution witnesses in the upcoming trial. They say the motion intimates that there is some level of mystery or intrigue surrounding which individuals Katie, as trustee and personal representative, has used as expert witnesses in litigation against Kouri. There is not. In fact, Katie's relationships with Todd Grabler, Brooke Carrington, or Matthew Throckmorton are, quote, secrets. They are some of the worst kept secrets in the world. It is a well-known, undisputed fact that Gabler is Katie's retained expert. Kouri has known this because Katie transparently broadcasted it to her for over 3 years. Suspected bias is not a free pass to seize sensitive information. Neither does it excuse litigants from standard discovery constraints, things such as relevance and proportionality. Katie has produced to Kouri's criminal counsel all non-objectable and discoverable documents. Kouri cannot have anything else. Just a reminder, Kouri's trial is set for February 23rd, with jury selection starting on February 10th of next year. Next year is going to be a very busy year for trials. We're going to be all over it. And of course, if anything new is filed in this case, I'll bring it to you. That's it for today. Kind of a short episode, but a few updates I wanted to get in. I hope you guys have a good rest of your evening, and we will see you soon.